As parents, the most important thing most of us will ever do is provide a safe, healthy home for our children. Parents are the most important people in a child's life. But sometimes, for the health and safety of a child, the juvenile justice system must become involved, and children may be removed from their homes until certain problems can be fixed.
Children should be with their parents if at all possible, and that's what the goal usually is. And if they can't, then children need to be placed in a safe, permanent, loving home as quickly as possible so they can grow to their potential.
Helping parents create a safe and healthy home environment is the goal of all the people involved in the juvenile justice system.
The state of Arkansas does not want to raise your children. We're not designed to raise children, and it's not our business to raise your children. So everything we do from this point forward is designed to get your children back to you.
An abuse or neglect case begins when a petition is filed with the court. This petition is the result of a report that has been received about your child.
The hotline that is handled through the Arkansas Department of Human Services. It's a statewide system in which you call in and you report what you consider to be an abused or a neglected child.
Once the report has been investigated, your children may be removed from your home and placed in the custody of the Department of Human Services. You will be given a copy of the petition, which includes a sworn statement of what is believed to have happened and the reasons your child was placed in DHS custody. This statement is called an affidavit. A summons attached to the petition will give the time and place of the court hearing, along with information about your right to an attorney.
It's all about best interest of the children, and that is quite understandable. But they also need to feel that there's somebody that's fighting exclusively for them in the goal of getting their children home.
Your attorney can answer questions and explain your rights and responsibilities as a parent, guardian, or custodian involved in this process.
The very most important thing they can do is listen to their attorney. They are specially trained to handle those kinds of cases.
Over the next few months, there are several people you will come into contact with. It is important to remember that these people are here to help you improve your life so your child can be returned to you.
The ultimate goal is to have the child's best interests identified and then work toward that goal with as much energy and consistency as you can. And then things will work out ultimately for the benefit of that child.
The judge assigned to your case presides over all court appearances and makes legal decisions regarding you and your child.
Most of the times, we're going to try to work on reunification, that is, getting the children back at home. I will tell the parents what they need to do to fix the problem. I will also explain to them that the law only gives them a limited amount of time to more or less get their act together.
The attorney for the Department of Human Services brings your child's case to the court.
I represent the caseworker for DHS or the investigator for DHS, and our case is geared toward providing the parents with services to allow them to reunify with their child.
Your lawyer, referred to as the parent counsel, represents your interests and rights.
Just let me know right now, do you want your kids back? If the answer is that they don't want their children back, then I ask what alternatives there are. Do you have family members? Do you want them adopted? What do you want to have happen? If they do want their children back, that's great. I have to have a willingness that they will work toward getting their children back. And if you do, I will fight to the end for you.
I was lucky. I was blessed to have an awesome attorney. He said, if you do everything I tell you to do and everything I want you to do, and if you follow my advice, he said, you will get your child back.
Your child will also be assigned an attorney called the attorney ad litem.
I represent the best interest of the children, and that's different from representing the child. Sometimes when your client says, I want to go home, returning home is not the best thing for them. And so I represent the best interest of the child as opposed to your typical advocacy role of representing the child's desires and wishes.
The DHS caseworker for the Division of Children and Family Services will work with you throughout the process.
A caseworker ensures the safety of the children we come in contact with. We refer our clients to different resources in the community in order to get their children back.
A court-appointed special advocate, or CASA, may be assigned by the judge to obtain information about your child for the court.
We attend all the meetings that are set up with the children, with the families at DHS. We do a lot of interviewing. We're there just to help. We're to gather information, reporting directly to the judge.
We can give opinions. We're not bound by some things that employee relationships prohibit or client-attorney privileges prohibit. A judge can ask us what we saw, what we heard, what we think.
Within the courtroom, there may be others present, including the bailiff, court reporter, one or more foster parents, and an interpreter if necessary. There may also be witnesses called by your attorney or by the DHS attorney. An abuse or neglect case begins on the day the petition is filed. If an emergency petition is filed, a probable cause hearing must be scheduled within the next 5 days. At this hearing, the judge will decide whether to move forward with the case. The DHS caseworker will begin working with you to develop a case plan. The case plan will include a description of the issues being addressed, the services that DHS will provide, and the permanency goal for your child.
You're really there to judge from a legal standpoint as to whether or not the Department of Human Services, an agency of the state, had the right to go into somebody's house and to take away their children. And you need to find out whether or not the health of those children or the safety of those children was really at risk.
If I determine that there is probable cause to believe that there's some type of abuse or neglect, then I will have to decide the further issue of where will the children live until we can come back to court for a full trial. We call it an adjudication.
The adjudication hearing or trial must be held within the next 30 days. At this trial, the judge will decide if your child is dependent neglected, which is the legal term for abused or neglected. The judge will then decide what services are needed and where your child will be placed. This is called the disposition. A disposition hearing may be held immediately or within the next 14 days. At this hearing, you will be informed of the judge's orders, including the case plan, for you and your child. Your DHS caseworker will offer services to help you make the changes necessary in order to follow the case plan and comply with the judge's orders.
They would set a set of goals for me. I would go, next time I went into court, I'd achieved all those goals. And then they'd set another set of goals. It's basically in your hands. It's whether you're willing to put in the time and the effort and go through the process.
The next step is a review hearing, which must be held within 6 months from the date your children were removed from your home.
Once I make a determination of dependency neglect, then we're required to have periodic reviews of the cases to see what progress has been made, keeping in mind that the whole point is to try to get the children back home as soon as we safely can do that.
Additional hearings may be held to make sure that everyone involved in the case is following the court orders, the case plan, and working toward making it possible for your child to return home. The final decision about whether or not you and your child will be reunited is determined at a permanency planning hearing.
You have to have the permanency planning hearing within 12 months from the time the child was removed. It can be earlier if the court decides it should be.
At this hearing, the judge will review evidence to determine the best outcome for your child. If you have made the necessary progress, your child may be returned to you at this time. If not, your child may be placed in the custody of a family member or someone else. It is even possible that the court may consider termination of parental rights.
What it means is they no longer have a legal relationship with their children. It means those children can be adopted. It means that they'll no longer be able to write letters, call, have contact with their children. It's as if their children are erased from their lives.
If a petition for termination of parental rights is filed, a hearing will be completed within the next 90 days. This is a drastic step that will be taken only if necessary to ensure a safe, healthy, and permanent home. To avoid this possibility, it is very important to follow the judge's orders to make the changes you need to make.
You're going to have to really work because termination is final. It's forever.
Having your life come under the scrutiny of someone else is never pleasant. But the most important thing to remember is that we, all of us, the judges, the attorneys, the caseworkers, the CASA volunteers, are here to help.
What we all want is for every child to have a safe home, a stable environment, a loving family that will nurture that child.
This is a turning point in your life. Starting now, these next few months will decide your child's future and your future as a parent. It could be your last chance, but it may be your best chance to create the home your child needs. We're here to help you, but the choice is yours. The time is now, and the clock is ticking.